Further hearing in the appeals of Grandview Private Trust Company and another against Wong and others.
Yes, Mr. Wilson, I'm sorry we're marginally later than
My Lord,
we planned, but we can adjust the timetable accordingly.
I'm very grateful, and we're grateful for the early start this morning. If I may start with a few matters arising from yesterday. I think I made a few promises to come back with a couple of points and references, and I'll do that. On the question of who the settlors are, which I know was a concern for my Lord Sales, if I might just give a couple of references. In the Statement of Facts and Issues, paragraph 5 at 1736, there is reference. It records the fact that the Court of Appeal proceeded on the basis that referred in the judgment to the founders being the economic settlors of the GRT. That one sees in various places in the judgment. One example that we've picked out is paragraph 166, which one finds at page 212 of the bundle, where it states in terms the founders who were the economic settlors, and then it talks about their wishes. And that's confirmed to some extent by paragraph 22 of Susan Wong's evidence, which you'll find at page 437 of the bundle, but I don't propose to turn that up.
Thank you.
And as my Lady Rose pointed out yesterday, that it is a very common practice in the offshore world to have the company settle assets of a minimal amount, be it $10, $100. I think inflation's taken the standard up to 100 now from the old-fashioned $10. And it's a practice that is referred to by Lord Walker in the Schmidt and Rosewood case. If I might just take you to that, starting at 2407 in the bundles. That's where we find Schmidt and Rosewood. I'll go straight to paragraph 1 of the judgment, which is at 2413. This is a paragraph that I think my learned friends for the respondents rely on, talking about the giving no reliable indication of who will benefit from the settlement. But just really at the end of the first paragraph, between letters G and H, one sees a description as a further cloak against transparency. The identity of the true settlor or settlors may be concealed behind some corporate figurehead. It describes the practice that my lady identified yesterday. While we're in Schmidt, if we could go then to paragraph 8, there's a description of the position as it was in Schmidt itself. Picking it up at letter C, it says, it appears that Rosewood does not accept that Mr. Schmidt was a settlor of either settlement. Certainly he was not named as a settlor, but in responses filed in the High Court of the Isle of Man, Rosewood has described Paqueret Limited, the named settlor, as simply a nominee, and has stated that Mr. Schmidt was involved in the setting up of each trust. Rosewood also stated in its answer that its involvement was simply to receive and pay out funds as Mr. Schmidt chose to channel through the Isle of Man. In the absence of other evidence, that justifies the conclusion that he was one of those who joined in causing the settlements to be made and funded and was in substance a co-settlor. So we can see that that practice is recognised in the courts. Certainly the board in Schmidt and Rosewood took the, if you like, the holistic view of stepping back and saying, well, who is the economic settlor here? And now, I pause there because, of course, if the founders weren't the settlors, my case, I say, would be even stronger, because their wishes would be utterly irrelevant to the question of purpose. But I'm afraid that's a bandwagon I can't really jump on, because we say it is clear that they were the economic settlors, and therefore it's their wishes, insofar as those wishes are relevant, that one has to look at. Whilst we're in Schmidt, it's probably worth just highlighting one paragraph that I'd like to go to at 2422, paragraph 36. I'm sure your Lordships and your Ladyship are familiar that the issue in Schmidt was whether a discretionary object was able to seek information about the trust. The old analysis had been that disclosure of trust information was on a proprietary basis. You had to say, well, I am the equitable owner of that property. You can give me information. Lord Walker said, well, no, that's not the answer. And so at paragraph 36, I just wanted to highlight what was said about the sort of structures that were involved. It says the board have to consider what claims or rights to disclosure the appellant has either personally or as his father's personal representative under two badly drafted settlements whose terms have been moulded by the sorts of influences mentioned above. One possible reaction would be that Mr. Schmidt and his colleagues have made their bed and they must lie on it. If they've deliberately entered into a web of camouflage, it is hardly for anyone claiming through them to complain that the position is not transparent. And it goes on to refer to Lord Green in the Howard de Walden case. If a taxpayer plays with fire, it scarcely lies in his mouth to complain of burnt fingers. However, the board consider that the inclination must be resisted. It's not been suggested that the settlements are shams or tainted with illegality, and it goes on. I highlight that passage simply because in their submissions, the respondents suggest that the judgment in Schmidt and Rosewood is somehow an endorsement of the sorts of practice for which the respondent is contending. We say the court enabled the claimant in Schmidt and Rosewood to get information, but to say that there is, if one likes, a ringing endorsement of the practices of a web of camouflage or cloaks against transparency is, I think, stretching it too far. And as I'll submit later, the issue that is before the board today is not one that was considered, didn't arise, this question of purpose. But I'll come back to that in due course. So that's what I wanted to say in relation to the question of who the settlor was. The second issue, I promised a couple of references. I think it's perhaps worth going to one of them, which it was in the context of my submissions about the role of settlor's wishes in terms of ongoing exercise of discretion, whether they're relevant to that question and how they inform purpose. One of the case that's perhaps the most helpful is Kane and Hutton. It's the 2021 Kane and Hutton case. I want to go straight to to page 6540, if I may. Picking it up at paragraph 113, where the judge quotes from Thomas and Hudson and describes it as an orthodox view of the role of the settlor, so simply that of creator. Once creation has taken place and there's no evident role for the settlor in the operation of the trust in his capacity as settlor, settlor drops from the picture absolutely and has no rights qua settlor, either to direct the trustees how to deal with the trust property or to reclaim the property that's been settled on trust. Now, as I submitted yesterday, that is an orthodox traditional position, and we all have to acknowledge, particularly in light of Pitt and Holt, that the settlor's role, given the relevance of the settlor's wishes to exercises of discretion, is greater than that. And that's recognised, we see at paragraph 114 of Kane and Hutton. I will ask the board in your own time to read from paragraphs 122. Actually, no, if we go to 122, it's probably worth looking at this stage. It refers to the Chambers case, which is in the bundle at 5993. And it considered the effect of settlor's wishes. It stated the settlors are entitled to express their wishes for the benefit of trustees, and trustees are entitled to take them into account. It can be important guidance to them in the exercise of discretionary powers. However, trustees, whatever settlor's wishes, must consciously apply their independent discretion exercising their powers. Wishes can only be taken into account if they are not inconsistent with the purposes of the trust as they appear from its written terms. So in response, I think it was to my Lord Burroughs' question yesterday, that's where I derive support for my proposition that ongoing wishes don't change the purpose of the trust. But I wish to be clear that we say that, as we say in our written case, a substantially contemporaneous letter of wishes can be relevant to shaping purpose. And a good example of a foundational document of the nature that we were talking about can be found in one of the cases that's relied on by my learned friends for the respondent at paragraph 106 of their case, the Dove case. I don't have the reference to hand, but I will. It's in footnote 104 of the respondent's written case. Sorry? 4301. It's 4301 in the bundle, and in that case there was a document called the Blue Book, which was intended to inform the way in which the discretions were to be exercised, and it was a clear companion to the trust instrument in that pension scheme. One final reference to give. My Lady Rose raised a question in discussions with my learned friend Mrs. Talbot Rice yesterday about the inadmissibility of subjective evidence in discerning purpose. A helpful reference may be to Lewin on Trusts, paragraph 7004 to 7005, which we find at 8266 to 7 of the bundle.
Sorry, what was the page?
8266 to 8267.
Thank you.
Where it deals with the question of subjective intention, evidence of subjective intention in the context of construction of the trust instrument. So it's a slightly different point, but we say that and it does explain there the underlying rationale being that no lawyer can safely advise a client on the construction of a written instrument if there's a whole manner of subjective evidence that one could bring into account to construe the document. And we say the same rationale applies when discerning purpose from a trust instrument and from any other foundational document, that one can't then suddenly say, well, actually, there's a whole host of other subjective things that the set law said.
Do you accept you could look at the letter, the contemporaneous letter of wishes?
Yes.
From the set law?
Yeah, substantially contemporaneous, and that's if it's within the category of foundational documents, that it could be a memorandum, and we see in some of the cases that there are formal memoranda which say, which make it clear how the discretion is intended to be exercised.
Yes.
But yes, so a letter of wishes in suitable terms would be included with that, and it's difficult to make a general proposition because one has to look at the terms and see whether it's intended to shape the purpose of the trust. Something of an abstract argument in this case, of course, because there is no such document. But we do accept that purpose can be shaped by foundational documents, which could include contemporaneous, or as the term I use, substantially contemporaneous, comes from Breakspear and Acton. It was Mr. Justice Briggs's term, so I can't claim credit for it.
But I think yesterday, in answer to a question that I posed, you accepted that subsequent expression of wishes could be relevant, provided consistent with the purpose of the trust.
Absolutely, it's the Chambers and Kane and Hutton point.
Yes. So in this sort of case, I realise this is not what we've got before us, but hypothetically,
yes.
How would it work? I mean, are we saying that on your submission, we're talking about a trust for the Wang family as defined, children and issue of the two founders? If one then had a subsequent letter of indicating the wishes of the founders in relation to widows or stepchildren, I think these are examples that were given, that would be relevant to take into account on your submission, would it, as being consistent with the purpose?
Yes. Well, the stages. So we're talking about something that couldn't possibly be said to be a substantially contemporaneous letter of wishes or foundation document. The way it would work in my submission is that the settlor would say, I think it would be helpful to join, to add in the widows, for example. The trustee has to consider that and then assess it by reference to the purposes. So if the trustee satisfies himself that taking that step would be for the benefit of the beneficiaries, or one or more of the beneficiaries, then he can do it. It's for a proper purpose. If the person that the settlor says, I'd now like you to add my friend who I just met, who's clearly, and there's no assessment, there's no ability, objectively or subjectively, to say that would be for the benefit of one or more of the existing beneficiaries, then that wouldn't be permissible. And we set out at paragraph 81.
So your control is whether it's for the benefit of the beneficiaries?
Yes.
So we would have to ask the test, would we, if we were talking about the widow example, whether the helping the widow would benefit the children and remoter issue of JC Wong. Is that the submission?
Or benefit one or more within that class.
Yes, because it's one or more of them. So, I mean, the classic, we set out at paragraph 81 of our written case a few examples of where we say there are some very clear cases where the purpose would be served by adding new beneficiaries. There is a principle, comes out of Re Pilkington, which is that if there is a power to benefit a beneficiary, it can be exercised for... benefit means a wide sense. So if I'm a beneficiary, payments can be made to non-objects because it's for my benefit for them to be paid. So, for example, to pay for my children's education is a classic example of that sort of benefit being conferred by a payment to a third party. Now, that can be done if you've got a wide power of advancement anyway, but the power of addition becomes significant because it's for my benefit, for example, to know that after my death, that financial support can be given. So adding my widow to a class of beneficiaries in that case would, in my submission, be clearly for my benefit. And
does it have to be that kind of financial benefit, or can it be some more, some different non-financial, moral or reputational benefit?
Absolutely. One of the well-established situations where payments can be made to non-objects is that which arises out of reclaw, where charitable payments can be made to discharge what the courts have termed a moral obligation on the part of the beneficiary. So that is very well established. And so we do set out some of those examples, being mindful, though, that it is, of course, impossible to come up with a list of all of the situations. And that is why we say there is a power that enables the class to be changed. The settlor, who sets up a trust for the benefit of his beneficiaries, can't. Well, he would be a bold settlor to say over the course of 100 years I can predict everyone that I would that should be included in order to benefit my beneficiaries, and the ways in which they can benefit. And one can see that, particularly in the modern world with modern families, this is a narrow class of issue. It may well be appropriate for the benefit of an existing beneficiary to add in their unmarried partner. It may be that there are children of the family who are not blood issue, who should be provided for, and it would be for the benefit of a beneficiary for them to be included. And so if we call it the power-specific purpose, is to provide that flexibility, but we say it has to be for the fundamental purpose, which is to benefit the class of beneficiaries under the trust.
Yeah, so in order to expand the class, there must be someone within that class who is benefiting from the expansion.
Absolutely.
Yeah.
And that's why that is, we say, the controlling feature of this otherwise unlimited, seemingly unlimited discretion.
And so would you accept that there's, if you like, a sort of mission creep subject to the principle that my Lord has said, that if you add, let's say, the widow as a beneficiary, so she's now in the class of beneficiaries, she may have her own moral obligations.
Absolutely.
Right, okay.
We say that the structure of the trust creates, put it in crude terms, a club of beneficiaries, people who are the objects of the settlor's bounty. That includes the Schedule 3 beneficiaries, who are, as my learned friend Mrs. Talbot Rice explained, the beneficiaries in the true sense, being those who are entitled in the absence of any exercise of discretion. They're the ones with the property, they've got the vested interest. The ones who are defined as beneficiaries are not, in fact, beneficiaries in a strict sense because they're only objects. And the significance being that there is no obligation on the trustee ever to exercise the Clause 3 or 4 powers. And that's... It's a very good old-fashioned deep chancery distinction, which Professor Smith, in his Massively Discretionary Trust article, explains why. What a lot of the things that we call discretionary trusts are not, in fact, discretionary trusts. They're fixed trusts with powers. From our analysis, nothing turns on that because we say that our analysis would encompass both the Schedule 3 beneficiaries as the true beneficiaries and the Schedule 2 beneficiaries, as they're called, as being those to whom the trustee must have regard when exercising their powers for a proper purpose, because we say they are the identified class of persons who are intended to benefit from the settlor's objects, settlor's bounty, looking at the trust as a whole. Now, coming back to my Lord Sale's point about the widow is added, and she's there. She's then in her own right, and if one looks at the Schedule 2 definition, it obviously includes those who are added from time to time. And it has to do that because if you amend the class and you've still got Schedule 2 saying this is the class, the trust doesn't work. And so that's how we see the question of identifying the beneficiaries for the terms, for the purposes of saying, well, whose interests have to be served? And if you come in properly, the widow example is an apposite one, then you're in that club, your interests be considered, and that's it. Because, of course, there is also a power of exclusion. If it's then decided that it's in the interests of one or more of the beneficiaries to exclude another beneficiary, that power can be exercised. And so that's how that flexibility works. I've sort of leapt ahead with that, so it means that I don't have to cover that ground where I was going to cover it. We finished yesterday by looking at Professor Finn's locus classicus. I just wanted, where he emphasised the importance of the interests of the beneficiaries at the heart of fiduciary obligations. I just very briefly want to show how that fits within the proper purpose concept, because one sees from time to time, and it's in one of the leading authorities, Cowan and Scargill, that the requirement to act for the benefit of the beneficiaries is expressed in terms of a duty rather than as part of a proper purpose rule. And I just want to square that circle, if I may. It's helpful to look at the article written by Lord Nichols. If we can go to 2896 in the bundle. I just want briefly to go to a few points on this. At 2898, Lord Nichols deals with the question of the purpose for which investment powers exist. We touched on this question yesterday. And it is stated in this form, the question begins to suggest its own answer. To pursue this further, it's necessary to have in mind first principles of trust law. Essentially, a trustee is a person who owns property not for himself, but for the benefit of others. The trustee has a limited range of powers to deal with the property, and he's circumscribed by duty. So we say that is the basic principle which underpins our entire analysis in this case. And then he says that the framework of powers in the next paragraph and duties exists to further the purpose for which the trustee is holding the property. Most often, the purpose is to confer financial benefits on beneficiaries over a period of years. Then on page 2899, he talks about the best interests of the beneficiaries. Now, he's doing this in the context of pension trusts, where there is a statutory duty to act in the best interests of the beneficiaries. But he does, he talks about it codifying the trustee's overriding obligations as ensuring that the trustee's duties and powers are performed in the best interests of the beneficiaries. Benefit and best interests are really interchangeable expressions. Both have a wide and elastic but not unlimited meaning. And then I can commend reading the rest of that paragraph, but in the interest of time, I won't go through it, other than to highlight where he says that to define the trustee's obligation in terms of acting in the best interest of the beneficiaries is to do nothing more than formulate, in different words, a trustee's obligation to promote the purpose for which the trust was created. And it's just worth noting at 2900, under judicial decisions, Lord Nichols notes that there are very few judicial decisions on this issue, and he's had to go back to first principles, and we say that to a large extent that's what we are doing with our analysis before your lordships and your ladyship. That isn't extrajudicial writing, but it has been cited with approval before the courts, indeed by my Lord Sales. I think it was in the F&C Investments and Barthélemy case, 2012, Chancery 613, and it does set out the basic principles in a very clear and coherent way. If we can then, just a reference to Thomas on Powers, which is at 8221 in the bundle, where it refers again to the duty to act in the best interests of the beneficiaries. And there is a...
Could you just give that page again, please?
8221.
8221, thank you.
Where it refers to the duty to act in the best interests of the beneficiaries.
And this is what you're quoting from?
I was
Is this Lewin or?
No, this is Thomas on Powers.
This is Thomas.
And he just talks about the wider application of the duty to act in the best interests of beneficiaries. The leading case on that is a case called Cowan and Scargill, which was the case where Arthur Scargill brought an action against the pension trustees of the NUM pension because they were looking to invest in foreign oil and coal. And it was the Vice-Chancellor who said, well, no, the best interests of the beneficiaries are the paramount consideration. Those are their financial interests, and therefore the trustee can invest. But what is being said in Thomas is that the duty is a generalised one, and that it wasn't, as we see at 10.160 there, it wasn't invented in Cowan and Scargill. It just echoes earlier cases, and it goes on to discuss that. And that's important, we say, that this idea of the best interests of the beneficiaries being the purpose or the obligation for trustees when exercising a power is one of general application in the context of fiduciary powers. If I can then very quickly go to the MNRPF case, which I'm going to start at 2221. I'll launch straight in. It starts at 2170 just for reference. But at 2221, this is the first instance decision of Mrs. Justice Asplin, as she then was. The paragraphs that I would highlight are 228 and 229, simply because what Mrs. Justice Asplin says there is essentially that the best interest duty is really just another way of describing the purpose of the trust. At 229, she says memorably, in my judgment, it's clear from Cowan and Scargill that the purpose of the trust defines what the best interests are, and that they are the opposite sides of the same coin. And so that's supported by Harries and the Church Commissioners. Now, I would make one point in relation to pension trusts, which is that there is a wider net of interests in a purpose trust, because one has employers, ex-employees, whereas a family trust established for the benefit of a defined class of beneficiaries is a simpler setup for discerning purpose, in my submission. But this principle, the fact that one absorbs or properly understands the best interest duty as part of proper purpose, we say is of general application, and that's how we get to our conclusion that the proper purpose of a trust of this nature, of the GRT, is serving the interests of the beneficiaries. But it's helpful to look at 243 over on page 2223. And there's reference there to some advice that was given by Mr. Christopher Nugee, Queen's Counsel, as he then was.
This is paragraph
243, my lord.
Thank you.
Where Mrs. Justice Asplin says that Mr. Nugee was correct in the way he advised the trustee as to the purpose of the amendment power, because the issue was whether an amendment power was properly exercisable. That advice is recorded at paragraph 70, which we find on 2187. And he sets out, the advice is set out there, and one sees that it stated that the duty to exercise the power in the best interest of the beneficiaries. And then we see at the leading counsel advised that a pension scheme trustee should focus on the overriding requirement for it to exercise its discretionary powers for the purposes of this trust and scheme and for the purposes for which the power was given. And then it gives an illustration in relation to a family trust. And so we see there that the advice that was given by Mr. Nugee, endorsed by the judge, draws a clear distinction, as we do in our case, between what we call the power-specific purpose and the overall or fundamental purpose of the trust or scheme in that case.
And what Mr. Nugee goes on to say, by way of illustration, is really your case, isn't it?
Indeed, indeed. And it's something, again, he's writing extrajudicially. Subsequently, the reference I'll give you is 8118. Sir Christopher has made similar points in that regard. And so we say that all of this shows that the purpose is ordinarily the best interests of the trust, the best interests of the beneficiaries, defined and deduced in the way that we have explained, which it is a point of difference between, I think, myself and my learned friend, Mrs. Talbot Rice, that she says that the focus is very much on the Schedule 3 beneficiaries because of their proprietary interest. Our analysis and our thesis allows one to take in the Schedule 2 beneficiaries when assessing whose interests are relevant to the proper purpose.
So in a different trust, not this trust, where the Schedule 3 equivalents are the Red Cross or random people, then presumably you would say one would then focus more on the class of objects.
Yes, yeah, it's very difficult to talk about hypotheticals, but one would step back and look at who are the objects of the bounty. Now, what I think where I may differ from the respondents is I say you can't ignore the Red Cross in that situation.
Right.
They are still, so if the trustee said, do you know what, actually, terrible world events, the Red Cross is going to get an enormous donation from this trust. You've named them as the object. I've got a power of advancement, to advance capital interest. I'm going to do that. Nobody could have any complaint on the basis of proper purpose, because the fact that it has been included as the beneficiary cannot be ignored. That is in the academic writings that have been highlighted, particularly Professor Smith, and one also sees, there's an article by Professor Matthews, and you've been referred to the Russell and Graham editorial. The complaint, and I think it is a justified complaint, is that sort of trust seeks to have somebody in as a beneficiary for convenience in circumstances where it's then said, oh, but you can ignore them. They're not really beneficiaries. That's not really the purpose. We say you cannot divorce purpose from the beneficiaries, because to do so collapses the trust into an impermissible non-charitable purpose trust, because you say, you've got beneficiaries who give you validity. One might say they lend you validity because they're not really properly there. But the real purpose is to do whatever the settlor wants. And that is, as Professor Smith says, a deformation of the trust.
So part of the bed that they're having to lie on, as we saw in the other case, is that that's how they've set it up.
Absolutely.
Those people they've chosen to be beneficiaries.
Absolutely so, my lady. And we're accused at various points of launching a radical and ambitious attack on the modern discretionary trust. I say there's nothing radical in the idea that if I, as a settlor, set up a trust of which the Red Cross is the only stated beneficiary, that my trustee might give money to the Red Cross, and that the Red Cross can exercise the rights of a beneficiary. I don't see that as radical at all. It is the beneficiary. It is the person, the entity, to whom the fiduciary duties are owed. Now, one of the reasons that our case is mischaracterised as a radical attack is that there are certain mischaracterisations within the criticism. Paragraph 8, I think it is, of the respondent's case summarises what they say our case is, and it really isn't. They say that we are saying that all powers in a typical family trust, irrespective of their terms, must be exercised in the interest of the beneficiary's objects originally identified in the trust instrument itself. Well, there's a number of fallacies in that criticism. The first is, we don't say it's irrespective of the terms. If a settlor wants to have a trust whereby wide discretions are conferred on a trustee and are exercisable by reference to his wishes and not the interests of the beneficiary, he can achieve that to a large extent. Our case is that he's got to do it in the terms of the trust. The Clause 8 power...
Do you mean with an express reference to his ongoing wishes?
Yes. Now, there are two issues that arise if a settlor does that. The first is that he can only do it to a certain extent. You were taken by my learned friend yesterday to the concept of the irreducible core of a trustee obligation. You've got to have enforceable rights of beneficiaries. So you can't draft your way to a situation where you entirely oust the interests of the beneficiaries. As Lord Justice Millett said in Armitage and Nurse, there is an irreducible core, which is enforceable obligations by beneficiaries. That is what you have to have for a trust. And that comes from Armitage and Nurse. And if the if a settlor, what a settlor can do subject to that is he can draft his way around some aspects of the interest of the beneficiaries, because if he does that in express terms, it informs the purpose. Perhaps it's best to exemplify it. The Clause 8 power could be expressed very easily to say, in exercising this power, the trustee shall be entitled to add a person to the class of beneficiaries, notwithstanding that it is not in the interests of the existing members of the class or any of them for that person to be added. He could go further and say that the person added, that he could have a power of veto over it. So it would show that nobody gets in without the settlor's consent. Or he could say, in exercising this power of addition, the trustee shall accept any request that I make, or shall act in accordance with a memorandum that I give from time to time. Now, that is perfectly possible. And what we say is that if the settlor takes the step of derogating from the principle that this power is exercisable for the benefit of the beneficiary, that's his freedom. He's not stopped from doing it, but what he has to do is take the consequences of doing that. The first of those consequences is, of course, the irreducible core. So there is a limit on how far he can go. But that requirement is mitigated to some extent in jurisdictions like Bermuda, because Bermuda has legislation which says that a settlor is entitled, without affecting the validity of the trust, to reserve and retain powers, including the ability to give directions to the trustee to do certain things. He can retain a power of revocation, and he can have a power of appointment. And the reservation of all or any of those powers does not affect the validity of the trust. A reference, it's in the bundle, I won't take you to it now, but it's at 8387. It's section 2A of the Trusts Special Provision Act 1989, as amended in 2014. So there is a statutory regime which says, yes, settlors, you can do this in the trust. You can be up front, you can reserve powers, you can hold the reins to a large extent without affecting validity. But the second consequence for a settlor is that it reveals the true extent of the control that he may have. What it does is it pulls away the web of camouflage that Lord Walker referred to. And we see from a line of cases, which I'll just give you the references to rather than going through them in view of the hour. But there's been a line of cases, some of which have been before the board, where the retention of interest and control by a settlor has had very significant implications. So the first is the Cayman case of TMSF, which came before the Privy Council. That's at 5555. Just to summarise that, there was a Cayman trust with a power of revocation, and it was held that that power of revocation retained by the settlor was property over which a creditor could appoint a receiver by way of equitable execution, thereby enabling the receiver to exercise the power of revocation, get the assets back, and then pay the creditors. The Pugachev case, which was the first instance decision of Mr. Justice Burse, is at 4218. That is a case where the judge did not find that the trust created was a sham, but held that when one looked at the nature of the powers and the control that Mr. Pugachev had over the settlement, the true effect of the trust was that the property was held for him, and therefore was again amenable to enforcement by creditors. And those words, the true effect of the trust, are quite are quite important, really. That what is being seen by the courts is that these trusts where it is said, oh, well, the settlor hasn't really got his fingerprints on it, but then actually controls it behind the scenes through various mechanisms, are in fact under the control of the settlor. And all our thesis says is this, that if a settlor is going to have that control, it shouldn't be an invisible hand hovering over the controls, it should be very visible. Because when one thinks about this, the web of camouflage metaphor used by Lord Walker, one has to ask oneself the question, from whom is that camouflage intended to conceal matters? Now, the answer generally is creditors. It may be tax authorities, divorcing spouses. It may be agencies seeking to recover the proceeds of crime. And dare I say it, in the current climate, it may well be it may be governments seeking to enforce international sanctions. One can see that this web of camouflage can be used to conceal the settlor's true degree of control. And now, it is not part of our case that there was anything nefarious being done by YC and YT Wang in relation to the GRT. It's not, that's not part of the case before the board. But one can very easily see that if the respondent's approach is correct, YC and YT Wang have no visible control over these assets. But what is being said is, well, their wishes from time to time are, as the Court of Appeal described it, the touchstone for the exercise of discretion. And the Clause 8 power would allow them to be added as beneficiaries and then have the entire trust fund appointed to them. And so one can very easily see, if there are settlor, if that is a model which operates in that way, the scope for using the trust as an abusive mechanism, abusive vehicle, is considerable. What we are saying, in contrast, is simply this. You look at the trust, you look at the letter of, the substantially contemporaneous letter of wishes or other foundational document, and that allows you to see what the control is. And if the settlor doesn't have control carved out in that situation, then his wishes may be considered by the trustee from time to time when exercising the discretion, if they further the purpose. But it's not just the plaything of the settlor, and it's not the plaything of the trustee to do what they want with. They have to serve, the trustee has to serve the interests of those for whom they hold the property.
You say that is a rule imposed by equity.
Indeed.
And you have to contract around it. If you don't contract around it, you're stuck with it.
Indeed. Yes. And that, I don't think that's a controversy. It's not, I don't recognise that as a radical proposition, my lord.
That I think is what you're,
Indeed.
What you're saying. And you go on to say, well, a benefit of that is that it prevents camouflage.
Indeed.
Yes.
And then one looks at the other analysis, and one says, well, that they're trying to preserve the camouflage. There is a criticism of our case in that we don't mourn the demise of the Red Cross Trust. Well, our analysis doesn't mean the demise of the Red Cross Trust. It just means that if you make a trust for the Red Cross and you don't do anything else, and you keep it all hush-hush and say, well, trustee, well, I'll tell you in due course how it's really going to work. That doesn't work. That sort of trust doesn't work. But there is a trust. It's a trust that the Red Cross is the beneficiary of. And as I come back to my previous proposition, if I create a trust for beneficiaries who are named, and I don't do anything else and carve out or contract around, as my Lord Hodges just said, why should I be appalled or concerned by the idea that those beneficiaries are beneficiaries in a real sense? It's a very difficult, as a trust lawyer, I find it very difficult conceptually to see what is objectionable about that idea that you have a trust, the beneficiaries are the beneficiaries, and the trustees owe obligations to them to the extent that they are not contracted around, as my Lord Hodges said.
Yes, because it's a matter of agreement that the power is a fiduciary power, as I understand it.
Yes.
Yes.
But the Clause 8 power here isn't qualified in the express way that I said. And the battleground between us, in many respects, is very narrow, in that we say, absent that limitation that we've been discussing, it is a power that is exercisable in the way we say for the benefit of the beneficiaries, like any other power, any other fiduciary power. My learned friends say, well, and the Court of Appeal said in the judgment, I think it was paragraph 181, but I might have the wrong reference, that, well, it would have been very easy. No, that's the wrong reference, but I'll find the reference. They said it would be very easy for the draftsman to have imposed limitations on the power.
And you say that's contracting into the that's contracting into the equitable rule. You say you don't contract into it; it's there. You contract out of it.
Indeed, in the way that I don't need to put in my power of investment. Trustee can invest in absolutely anything he wants, but he can only do so for the benefit of the beneficiaries. I don't need to say that because there is this overarching proper purpose of acting for the benefit of the beneficiaries, which is a constraint that one finds from beyond the four corners of the power.
Trustees couldn't rely on the limited wording of Clause 8.2 to say, well, look, it says that it's only the delegates of the trustees who can't pay money to their creditors. It doesn't say anything about the trustees not being able to do that, because the answer would be, well, you're restricted by the application of the general law from doing that. They didn't need to put it in.
Absolutely. And you know, well, trusts would look very different if one had to contract into the duty or the obligation to act for the best interest of the beneficiaries. One would have to put it in at every turn. Paragraph 19 of their written case, the respondents actually acknowledge the operation of the duty more generally, because they use the example. They say, for example, a decision by a trustee to change the proper law of a trust to stifle a claim against it would infringe the proper purpose rule, but a decision to do so for the purpose of exporting the trust to a more attractive trust's jurisdiction would not, even though the outcome is the same in both cases. We wholeheartedly agree with that, but what they're not... They've used the term more attractive, and one has to just unpick that slightly, because one has to say, well, what does more attractive mean? It actually means beneficial to the beneficiaries in my submission. If one had, for example, the obvious situation of a more benign tax environment. But they accept there that the trustee can't do it for his own purposes to stifle a claim. And we submit that equally he can't simply do it because the set law wants to do it. I mean, for example, it might be the set law who says, well, I don't want my beneficiaries suing my trustees for that breach of trust. Why don't you shift it off to the jurisdiction of Utopia, where they've stopped claims for breach of trust? Well, that would be impermissible because it's an improper purpose, because it doesn't serve the interests of the beneficiaries. So it applies to that power, the wide power of changing proper law without contracting in, as my Lord Hodge put it. It applies to the power of investment, as it's unarguable, the contrary proposition, because we've actually got authority on that, which is Cowan and Scargill. The question that one has to ask rhetorically is, why should the power of addition of beneficiaries be any different? Now, the only argument that one can conceivably have is say, well, if you couldn't exercise the power for the interests of that class of beneficiaries, then there might be a necessary implication. If you say, well, the power is intended to have some effect. If it cannot possibly be exercised for the benefit of beneficiaries, then there might be some force in saying, well, it must be intended to be exercised slightly differently. But in paragraph 81, which I mentioned before, we've sought to give some examples of how it very much could be exercised in the interests of beneficiaries. And if one accepts those propositions, then any argument of sort of necessary implication goes away. Even if one might say that the list is fairly small. in paragraph 81. It's not intended to be exhaustive. And the notion that flexibility the flexibility of the beneficial class is not included to benefit beneficiaries is one that just doesn't follow. That flexibility can be there to serve their interests. So that's why we say there is a fundamental fallacy in the criticism of us that we say it's irrespective of the terms. I think I've dealt with the point that we don't say it's only ever the interests of the original beneficiaries that are relevant to purpose. That's not our case, as I've demonstrated by reference to the example there. And
I'm just on the notion of contracting into equity or contracting out of it, as my Lord Hodge was. And presumably you would say that if you had to contract into the doctrines, you'd lose half the benefit of equity, which is its flexibility and ability to react to circumstances as they arise.
All right. Yeah, indeed, my Lord.
Whereas if you had to contract into it, the parties would be forced back on their own resources, trying to predict a whole lot of uncertainties in the future and then make accommodation for those.
Absolutely. I mean, on a broad sense, I would say actually the settlor does contract in because he gives property to a trustee to hold for a beneficiary, and that creates that relationship which brings with it. It's that separation of legal and equitable ownership, the fact that somebody owns the property and has to manage it.
Yes, if you create a trust, you're contracting in.
You're contracting in, my Lord.
But so far as the powers are concerned, you have, by creating the trust, contracted into equity. And if you are to remove the rules of equity, you must do so expressly or
Absolutely.
by implication. But I need to warn you that the question of time, you
Yes.
are eating quite heavily
I
into
am,
your reply
and
time.
I'm going to...
Mrs. Talbot Rice's reply time. So I hope that the appellants as a group are bearing that in mind, because this time doesn't come out of Mr. Howard's time.
It's always important to note when the bench has had enough of one, so I will move
I'm not
rapidly to
saying
conclusion.
I'm just all I'm saying to you is I will police the time fairly.
Well, I will, as I say, move to conclusion, because those are the I think I've dealt with the two of the fallacies that are in the criticism of us. The third is that we say trust can only ever have one fundamental purpose. Well, I hope that my submissions have demonstrated that's not the case. We say that you can draw the purpose wider, provided you don't erode the irreducible core minimum. But I'm afraid I come back to saying the same thing again. You have to do it in the trust instrument. You have to show that that's what the position is. So, my lords, my lady, I think that's probably what I wanted to cover, other than to say, in conclusion, drawing the threads together, that really all we're seeking to do is apply proper, orthodox, equitable principles to trusts which have developed as a matter of practice. It is said in a number of cases that there was examples given of various cases in the respondent's case where they say, well, the sort of trust that would not operate as intended, potentially, have been endorsed by the courts. The list included Schmidt and Rosewood, I think the Reed Beattie case, and the decision of Mr. Justice Hoffman in a company case at first instance. We say the very simple answer to those authorities is that they were not dealing with this question. It was not before them. And it may be that the principles that we are seeking to apply dare I say it, are at variance with the practice that has developed in certain jurisdictions. But the law develops by reference to the principles, not the practice. It's not driven by the practice. And if the practice has diverged from the principles that we are setting forward, then it has taken a seriously wrong turn at some point. And what we are doing is asking the board to put trust law back on the right track by making what is, we say, a fairly modest alteration to the expectations of those in the trust industry. It doesn't stop people setting up vehicles which do exactly what people want them to do. They just need to be upfront about it and take the consequences of it. I should just deal very, very briefly with two authorities which are cited. Cited against us. They are the Tam and HSBC case at 7265 and the Shupak Nin case at 7003. They are cited as proposition in support of the proposition that there are cases against us on this proposition, on the notion that the purpose of exercising a power of addition is to serve the interests of the beneficiaries, or the proper purpose as we would frame it. We say those cases don't support that. They're both first instance decisions. The Tam case was one where the trust was accompanied by a very clear memorandum of wishes, absolutely contemporaneous with the trust, which named somebody who was not in the class of beneficiaries as the specific recipient of a particular property. And so we say our analysis accommodates that situation because it was clear, taking the foundational documents as a whole, that this person who wasn't named in the trust instrument but was named in the memorandum was clearly an object of the bounty. And so we say that that was fine on that basis. It doesn't represent an obstacle to our analysis. The Nin case follows a similar fact pattern in that there was a contemporaneous memorandum of wishes. That included 11, I think it was, children of the deceased, some of whom were legitimate, some of whom were illegitimate, of the set law, some legitimate, some were illegitimate. There was a question of construction on the trust instrument as to whether the illegitimate children could benefit. Because counsel had agreed that they couldn't, the judge, expressing some reservations about that, said, well, I won't contradict that, and then said that the trustee could exercise the power of addition to bring the illegitimate children in to the class of beneficiaries. And again, so we say it fits within our thesis and our case, and isn't authority for any contrary proposition. Those two authorities are the ones that are referred to in Lewin at paragraph 33060 as authority for the proposition that you can't exercise a power of addition for the benefit of beneficiaries. Well, we say that is just plainly wrong and isn't what actually happened in Tam or Nin.
What was the Lewin reference?
Paragraph 33060. I'm afraid I don't have the bundle reference to hand, but
you say that's wrong.
We say those cases are not authority for the proposition because there are plenty of examples.
Thank you.
And the respondents are lighted on what's said at paragraph 147 in that respect of Nin, and we just say it's not authority, it's demonstrably wrong. And so, my lords, my lady, unless there are any other matters that you'd like me to address, for the reasons in these oral submissions, together with the written case which we rely on in full, and subject to our reply, those are our submissions.
No further question. Thank you very much. By my calculation, the appellants have used 20 minutes more than their allocated time, and therefore, Mr. Howard, that gives you the entitlement tomorrow to go on to 12:35.
My Lord. I think they've actually used half an hour more than they're allotted.
I think it was half an hour. Well, I mean, there were delays due to setting up computers and so on. So, if necessary, we can either sit on slightly or sit slightly earlier. I wouldn't want to unduly cut down the respondents, the appellant's reply, totally. But yes, I will accommodate you to give you your full time.
My Lord, I'm grateful, Lord. The central issue my lords and my lady, on this appeal concerns the scope and purpose of the power of addition in Clause 8 of the GRT Trust Deed, which power was exercised by the trustees. And just stopping there for a moment, that was a power exercised by the trustees. There's no suggestion that the settlors exercise the power or have the right to exercise the power. We've had suggestions to that effect. That's contrary to the findings of fact and the basis on which this case has been decided. So it was a power given to the trustees, exercised by them. Now, in our submission, the answer to these issues, scope and purpose, depends upon an analysis of what the settlor, as the author of the trust, intended. And again, so it is put out of the picture, we are not saying, and nor has the Court of Appeal said, that the settlors could change the purpose of, or the scope and purpose of Clause 8, subsequent to creation of the trust. It's not what we've ever said, it's not what the Court of Appeal has said. Now, the critical question in this case, we suggest, is how you go about ascertaining the settlor's intention. We say that is a simple point. The intention is to be ascertained in the usual way by applying ordinary rules of construction to the trust and in the light of the admissible factual matrix. Now, in our submission, what the appellants say, at least this is as we understand of Winston's case, is that you actually do not go about ascertaining the intention in the usual way. Indeed, I think this would follow from, certainly from Winston's, probably from Tony's, because what Winston says is that there is a rule of law that regardless of the terms of the power, or the circumstance of the trust, or the settlor's intention, a power to amend or to exclude beneficiaries cannot be used to alter the so-called substratum of the trust. And what is meant by that prohibition appears to be that a power can't be used to make amendments that could not have been foreseen by the settlor, and that is so apparently notwithstanding that the purpose of the power was to cater for unforeseen circumstances. We all remember the famous dicta about known unknowns and unknown unknowns and so on, whatever the particular gentleman meant at the time, but it was fairly graphic as to the fact is you don't have a crystal ball, and one of the things is when you set up a trust which is going to last 100 years, you may well want to give, and I'll show you authorities which have said this, to the trustees very extensive powers to cater for changes of circumstances which you cannot possibly foresee. YC and YT, when these trusts were set up, were men in their 80s, having had, as you know, enormously successful entrepreneurial careers, but they obviously were towards the end of their life, setting up a trust which was going to last for many years later. Now, the primary case, the substratum case, we say is plainly wrong for the reasons given by the Court of Appeal, which I will come on to develop. But, I mean, in simple terms, when one looks at all of these cases concerned with substratum, it ultimately is simply a question of construction as to what the power is. Now, that primary case was the only case that was advanced below. Tony seems to advance a further case, which is sometimes has moved in the course of this morning. As I understand it, he says, if the settlor originally identifies certain individuals as beneficiaries in the trust instrument, or one can ignore the word originally, if you identify individuals as beneficiaries, then the settlor is, again as a matter of law, regardless of his actual intentions, to be taken to benefit those individuals alone. I think what Tony says, well, it extends to people you add in later as beneficiaries. But he says it's not legally permissible, even by giving the trustee a wide and apparently unfettered power of amendment or addition, to empower the trustee to benefit anyone except those individuals. Now, Mr. Wilson this morning, I think, says, oh, well, actually, no, I don't go that far. I think he says you can do it, but you have to expressly say so. But, so if that's the case, it really just comes down to a question, a fairly narrow question of construction. But I'll deal with it on both bases. But certainly the case that has been put forward in the written case, we suggest is an extreme case because it would defeat what settlors intend and particularly and importantly destroy the flexibility that is the hallmark of the modern discretionary trust. Now, before I go further into consider the construction issues, I want to make a couple of three introductory observations. The first, my lord, is this, my lords and my lady, is this. GRT is a discretionary trust. The settlor named the children and issue of YC and YT as the initial discretionary objects or beneficiaries and also as the default beneficiaries, but gave the trustee a power of addition or exclusion in Clause 8. And just en passant, a point that was raised by Winston's counsel that somehow the pleaded defence is saying something different. That's a false point if you look at the defence as a whole. She referred to paragraph 9. Paragraph 13 refers to this point. Now, there is no restriction, and I think this is common ground, there is no restriction in the trust deed on who may be added or who may be removed. Now, two short points about discretionary trusts. A discretionary trust in the narrow sense refers to a situation where the trustees are obliged to distribute all of the trust property but have a power of selection as to which members of the class receive it and how much. That's, as it were, the narrow and rather, in fact, today, old-fashioned discretionary trust.
And that can include a power of accumulation, can it?
I think it could. Not sure that it would. Yes.
I would have thought it could. I mean,
yes, it could. But
usually,
yes.
Yes. So a power of accumulation doesn't mean that it's not one of those old-fashioned.
No. I mean, an old-fashioned, as it were, the sort of trusts that you look at from the 19th century would have that would be a feature. But the point I wanted to bring out, what's much more common today and has been for many years, is a discretionary sense in the wider sense. That is to say, a trust structure in which the trustee holds a number of dispositive powers or discretions, such as wide powers of appointment, without any obligation to exercise those powers. Now, a power of addition and exclusion is a characteristic feature of discretionary trusts in this wide sense. And the two authorities I'd like to go to at this stage. First is TR Technology in 1988, which is at 5080. And if you go to 5087, this is Mr. Justice Hoffman in 1988. So obviously a leading chancery practitioner now on the bench. And if you go to the bottom of the left-hand column on 58087, he refers to a trust which was called the Fermandale Trust. And then if we go to the next sentence, it was a typical offshore trust. And since a number of those trusts feature in these proceedings, it may be useful to describe their general characteristics. The named settlor is usually a stranger to the transaction who's been requested to lend his name to a document which records, in many cases truthfully, that he's provided a nominal sum as the initial trust fund. And then if we skip over the facts to the top of the next column, the name of the person providing the assets subsequently added to the fund, which I may call the real settlor, does not appear. Miss the next sentence. The trustees are given a wide discretion to pay income and capital to the beneficiaries, but the persons actually contemplated as beneficiaries are not necessarily named in the document. Instead, a local charity or some other person will be named, and the trustee given a discretionary power to add to the list of beneficiaries. Here, then, he refers to who were named as the beneficiaries. Sometimes, he goes on, the trustee will be given a letter of wishes by the real settlor saying whom he wishes to benefit. Sometimes, the real beneficiary, who may be the real settlor himself, will remain a matter of oral understanding between him and the trustee. These trusts, therefore, reveal very little and depend upon trust and confidence reposed in the trustee. To give effect to expectations and understandings which may not be legally enforceable. The business of providing offshore financial services requires a reputation for probity and efficiency in executing such trusts in accordance with confidential wishes of clients. Now, I think a point that my Lady Rose made said, you made your bed and you have to lie on it. The bed you've made is that in the example Lord Hoffman, or Mr. Justice Hoffman as he then was, is talking about, is that the trustees may not act in accordance with your wishes. They are, as is common ground, they may have to take account of them in their consideration, but they may have differing views perfectly legitimately. And that's the risk you take. They're not the letter of wishes or the oral understanding or just it may be an unwritten understanding. None of that is enforceable. But the fundamental point that His Lordship is making is that these trusts have been on the scene. This is 1988, something which here as a Chancery judge at that time and a leading practitioner is well aware of. Now, trusts with these characteristics were well known then, and the use of such trusts has increased. Now, that is why in Schmidt and Rosewood, Lord Walker explained in terms that it is almost always a mistake to assume that the individuals named in the trust instrument are the only ones intended by the settlor to be the object of his bounty. And we should go to Schmidt and Rosewood, although you were taken to it this morning. We, I think, skipped over the critical part. So if you go to page 2413 in Schmidt, we're going to come back to look at this case in more detail because it is an important case. But if you go to, just for my introductory points at 2413, you were taken to paragraph 1 where Lord Walker explained that it had become common for wealthy individuals to place funds at their disposition into trusts regulated by the law of and managed by trustees resident in territories with which they have no substantial connection. He then makes a point about tax havens, and then explains that G, the trusts and powers contained in a settlement established in such circumstances may give no reliable indication of who will in the event benefit from the settlement. Typically, it will contain very wide discretions exercisable by the trustees, sometimes only with the consent of a so-called protector, in favour of a widely defined class of wishes. The exercise of those discretions may depend on the settlor's wishes as confidentially imparted to the trustees and the protector. As a further cloak against transparency, the identity of the true settlor or settlors may be concealed. Now, one can consider whether or not, for instance, and this has got nothing to do with this case, but obviously is current in the light of current things going on, whether for money laundering purposes greater control needs to be exercised of monies going into trusts and so on. I think of Russian oligarchs and so on buying properties, that sort of thing. But in our submission, this case is about the way in which trusts operate, and at this stage simply show you Schmidt and Rosewood and commend it to you as an example of the courts recognising that trusts there, that was a trust where a charity was the default beneficiary, where the people who were actually intended to benefit are not identified, but the Privy Council didn't in any way question the validity of it. Now,
well, no one's asserting that this is a sham, and you say that these are examples of the court recognising this situation. I'm not quite sure what you mean by that. This is all fine as long as everybody gets along and everybody plays the role that they're supposed to play, and the beneficiaries are all happy with that, and the settler is happy with that. But when somebody starts being very unhappy with it and brings the matter to court, then the question is, should this court recognise that by attempting to enforce in some way what's actually going on when that appears to be inconsistent with the wording of the actual trustee?
Well, my lady, that's not what this case is actually about, though. I mean, certainly on our case, we're not suggesting, and that's why we need to be quite careful as to actually what the issue is in this case. Our case is that Clause 8 of the trust deed gave the trustees a wide power to add additional beneficiaries. Now, come on to how that operates. Now, if one says, no, it didn't, we're not saying, well, because the settlors might have intimated a wish that they would like that to be the case, or they'd like the beneficiaries to be changed, that is somehow relevant, that there's some secret agreement or something like that. That's not what this case is about. On our case, this case is actually just about construction of Clause 8. Essentially, we say that's what it all comes down to. Whether or not Clause 8 was there, the rival cases to some extent come down to this, if one stands back from all of this. The case that's being run is that by the appellants is that Clause 8 can only be used, they put it in various different ways, but Tony says to add people which would benefit an existing beneficiary or object. Winston says it can only be used, or it mustn't be used if you're going to undermine what he says is the substratum, although I think it seems to be coming back to the same point that you've got to only if you're going to add a member of the family. Whereas we say, and this is the distinction, we say Clause 8 is there to cater for the changes of circumstances that might arise. And that when if you say, what is the constraint on the trustee? Why are you giving the trustee this power? The settlor, it provides the bounty for the trust. What the trustee does, and you'll see this is exactly what Mr. Justice Hoffman says in the Reed Beattie case, what he's to do when he exercises his powers is to consider what, as it were, he's standing in the shoes of what the settlor would have wanted him to do with his bounty. So take a simple situation. Take a situation where you set up a trust, where a discretionary trust, let's say you have a charity as the default beneficiary, let's say you name your 2 children as objects of the trust. Let's assume what happens is that the children, what the settlor in setting up the trust was hoping to, or intending to benefit the 2 children. Now, and the trustee knows that that is what happens. Now, one child, it becomes, both of them become in different ways ne'er-do-goods, or one becomes a ne'er-do-good and one wins the lottery. The question is the trustee entitled to take account of that change of circumstance and say, well, in this change of circumstance, they're now not people, as it were, deserving of the bounty. The settlor has given me this right. Is the trustee entitled to say, well, actually, now I'm going to add someone else? Now, the someone else has got to consider it as someone who the settlor would have wanted his bounty to go to. So no one suggests on our side you could just add Battersea Dogs Home, unless Battersea Dogs Home was something which had some connection and you had a reason to believe that's the sort of thing the settlor would be interested in. But we say it's not a terribly complicated concept, and that is indeed what one sees recognised in the cases.
Well, I wonder about that, because you were reading paragraph 1 of Schmidt,
yes.
and at letter G, it says typically the trust will contain very wide discretions exercisable by the trustee
yes.
in favour of a widely defined class of beneficiaries.
Yes.
So that description is envisaging that the trust deed will have a class of beneficiaries and the discretions will be exercised in relation to them.
Because remember, Schmidt, the whole point in Schmidt, on the facts, the son the trust is set up by a Lukoil executive. Yes. There are two trusts. We will have to come back to it. There are two trusts. And there were some mistakes in what was done, but one trust, the default beneficiaries were intended to be charities, I think R&LI, or something similar, and the beneficiaries were other executives of Lukoil. The son wasn't mentioned as a beneficiary, but he was somebody who, his father then died, and there was a later letter of wishes, but he was somebody whom it was anticipated would have been in due course, may well have been added as a beneficiary.
So the father was a beneficiary, or was on the list of...
No, the father was an object, yeah.
He was an object, yes.
Yeah.
Yes.
Yeah.
So, but that model would fit the appellant's model. That the father would have wanted the son to be catered for.
Well, no, the father died.
Yes.
And so there was no basis,
yes.
the father having died, for the son, on their case, for the son to be added, because the father didn't have any vested interest when he died.
No.
And
no.
So.
But it's this case, as described in paragraph 1, and as you're describing it now, and I'll have to read it with care, it is a far cry from the present circumstances.
Well, my lord, I'm not saying this case is the same as ours.
No.
But what I'm saying is that Schmidt is an example. I mean, the point I was making is, the point that Lord Walker makes is that the trust deed may give you no reliable indication of who was intended to be the object of the bounty.
But that's not our case, is it?
Well,
because Schedule 2 does give you an indication.
Schedule 2 gives you an indication subject to Clause 8.
Well, I appreciate that, but that is the point I think my lord was making, that our trust here is a very different trust from the sort that Lord Walker and Mr. Justice Hoffman are
our trust is one. In the type of trust that Lord Walker's talking about, you may actually have no idea on the face of the trust who is really going to benefit. I mean, the classic, the extreme one is the SOFA one, where you remember the default beneficiaries are partners, I think the youngest partner at Freshfields or somewhere, and the beneficiaries, the objects, are also partners in other law firms. I mean, other than saying, well, it seems incredibly unlikely that it's ever intended any of those people are going to benefit, it didn't tell you anything else. But our case, I mean, we don't shrink from what the purpose of the trust was when it was set up. I mean, we need to look at what the facts are about that in a moment. But can I just...
Sorry, isn't the point being made by Lord Walker in paragraph 1 about not being able to tell who will actually get the benefit, that it's because you've got a widely defined class of beneficiaries? He's not suggesting it'll be someone outside that class of beneficiaries who will get the benefit. It's just there are 2,000 people. You don't know which are the lucky ones that get it.
That's not right in that case.
Right.
The person who's bringing the action is not within that class. He could only be he could only get a benefit if he was added to as an object at a later stage.
Certainly, for my part, you'll need to sort of take.
Yeah. No, it's very important. That's what the case was all about.
Right.
It was somebody who was.
But it's not what Lord Walker is saying.
No, and that's just an introductory paragraph. That's all.
No, but you were founding on that introductory paragraph to explain the width of these trusts. Yeah. And all I'm putting to you is that the introductory paragraph in the passage I read out to you does not support your contention. It may be on the facts you can say, well, that wasn't an exclusive definition. Yes, Lord, nevertheless, it is that what is said there is perfectly consistent with the appellant's case.
The class of people that Lord Walker is talking about in our submission includes people who can be added, just as in our case, under Schedule 8.
And you're going to show us that, because he doesn't say it in paragraph 1. He may say it later.
Yes. That's my only point, is paragraph 1 itself doesn't go that far.
Let's come back to that. Can I just then...
So could I just be clear? Your submission is that when a phrase like widely defined class of beneficiaries is used, for the facts of our case, the widely defined class of beneficiaries is effectively the whole world minus any exclusions. Is that right?
On our case, the class of beneficiaries here, because you can add, includes the whole world except for the trustees.
Right.
Themselves.
I see.
Yeah. And are you going to address, I don't even know whether it's relevant to this case, the controversies as to whether that sort of width of class is void or valid?
Yes.
You are?
I am.
Yes, thank you.
Yeah. And we say, when you look at Barden in the House of Lords, that has been analysed, and we say it is valid.
Thank you.
But can I come back to that? Can I give you two references to academic commentary on, and just looking at things generally at the moment. There's Professor Hayton, or Mr. Justice Hayton, at 2707 to 2708, and Professor Nolan at 2913. Now, the power of addition and exclusion, can I remind you of the Court of Appeals judgment at 224, at paragraph 194. And the Court of Appeal in paragraph, it is President Clark at 194, make the point, explain the obvious reason for granting a power as wide as this is to allow the trustee to take account of changes, including in particular unforeseeable or unforeseen ones. Such changes might include the fact the need to benefit the founder's issue had been satisfied by other means, or that such issue were no longer appropriate recipients of the bounty, and he doesn't derive much assistance from the third schedule. And that point that was being made there, can I just give you the reference, is also borne out, or actually perhaps we could turn it up, in our written case at page 1876. We quote at the foot of page 1876 from Mr. Justice Briggs, as he then was, in the Stenerline case, where he said at the foot of the page, he also observed at 97 that a power to amend is intended to be of practical use in circumstances which the original framers of the power may have been unable even to imagine at the time of its inception. And we give, in footnote 39, we give some other references to that. And so we say the reason why a wide power of addition of this type is included is there are two things that one needs to take into account. One is that you're seeking to cater for unknowable changes. The other is, the important thing is the point that Mr. Justice Hoffman made, which is that the settlor trusts the trustee. That's the whole nature of it. Now, so that's the first introductory point I wanted to make. The second is one that your Lordship and Ladyship have heard from my friends about, concerning the approach that one needs to take to the questions in this case, which is the analysis in Pitt and Holt, which is there are three different grounds on which the exercise of a power can be challenged. There's excessive execution, inadequate deliberation, and the proper purpose rule. And excessive execution concerns exercising a power to do something beyond the scope of the power, doing something that the donee is not authorized to do as a matter of construction or implication. And by way of contrast, the proper purpose rule concerns exercise of a power within its scope, but for a purpose other than that for which the power was conferred. Now, inadequate deliberation obviously concerns the duty to give proper consideration of the relevant matters. We're not concerned with that on this appeal. Now, so, but by way of background, or considering how the relevance of the deliberation rule, what the appellants have to demonstrate is that although, as is the agreed facts for the present purposes, the GRT trustee took all relevant considerations into account and ignored irrelevant considerations and did not act arbitrarily, nevertheless they acted for an improper purpose. Now, the final point, which we mustn't lose sight of, this is a summary judgment application that comes before you on the assumption that the respondent's evidence is true. So what are the key facts? The starting point is that YC and YT Wang had deeply held convictions that personal wealth should be used to benefit society. Your Lordship and Ladyship will see that set out in a number of places. Perhaps I won't spend time going through it now, but the best place to see it is in the bylaws of Grand View, the trustee of WFT, at page 475. Now, in keeping with that belief, the founders decided in 2001, when GRT was created, not to leave their wealth to their children. That you'll see at paragraph 7 of the Court of Appeal's judgment. So it's important to understand this. This GRT trust, there's been a lot of discussion about typical family trust. This wasn't a trust which was being set up, as it were, as a vehicle simply to provide benefit to the 17 children that YC and YT between them had. It was set up because they wished, the expression by which they're described as the founders wished to incentivize their children to promote the success of FPG and their vision. That's set out in the Court of Appeal's judgment at page 147 at paragraph 9. If I can just ask you to turn that up very briefly. And perhaps if you...
Sorry, can you just give me the paragraph?
Yeah, it's paragraph 9, my lord. And it's worth... I'm not going to spend time reading it out, but paragraph 8 explains what happened how this evolved. So the original plan, which is being spoken about in paragraph 8, was that children would serve as directors of the company that was to be the trustee, and they would benefit personally in some very limited way. As it said, this was intended to ensure that family members who devoted time and energy in supporting the growth and prosperity of FPG and the various charitable foundations were sufficiently motivated. So that's what the founders had in mind originally. And then at paragraph 9, they changed the structure, as it's explained. The original proposal was modified. It was decided instead of making provision within the Bermuda Purpose Trust for family members to be incentivized, there would be a separate private discretionary trust from which those family members could potentially benefit. The structure was designed to align the interests of the children as potential beneficiaries with the continued growth and perpetuation of the success of FPG. Formation was intended to incentivize the descendants to perpetuate the success of the FPG companies and thereby to achieve the wider goals. So he says in the last sentence, it is apparent from this description that GRT was not simply a trust to benefit the founders' issue, but a means of achieving through them the ongoing prosperity of Formosa Plastics Group and the fulfillment of the founders' vision. Now, what happened subsequently was that in 2005, the founders decided they were going to retain their personal, which were held onshore in Taiwan, shareholdings in FPG. And that is explained in the Court of Appeals judgment at paragraph 25. The consequence of that, of their retaining these shares in their own name, was that enormous amounts of money would in due course be inherited by their children.
Can I just ask you about that? How does that arise? I mean, how will they? Of course, they have actually both died, so we might now know, but how would they inherit? Was that a certainty?
Yes, it was a certainty.
Is that because of the Taiwanese laws of succession?
Yes.
What, that personal estate must be divided equally amongst heirs?
A certain amount has to go to wives, and there's a debate, which you don't need to get into, about how many wives they had. So there's a dispute as to whether YC had 3
But anyway,
wives.
the point, what you're saying is that a percentage of a deceased's estate, is this right, has to go to certain heirs. I mean, the assumption is made in paragraph 25, little 2
yes.
of the President's judgment that that if they YC and YT retained their personal shareholding, their heirs, including their children, would, when they died, inherit wealth. And I just wondered what the basis of that was.
Well, firstly, that was the evidence of what actually was their understanding at the time. It's in Susan Wang's evidence. This is where this comes from. So, my understanding is that 50% of the estate would go to the widows,
right.
Widow or widows, and 50% then to the children.
I see.
But whether, and that's in fact what happened.
That is, in fact.
That is actually what happened, and neither of them left a will.
Right.
So that what happened was 50%. There's. I don't want to go down a sort of a rabbit hole.
No,
there's all sorts of disputes, and there still are. But
yes.
50% certainly went to the children. Let me just tell you very quickly. YC. There's a dispute as to whether YC had 1 wife or 3 wives, and disputes about whether bigamy was or wasn't outlawed in Taiwan at the time. And then there's a dispute about YT, whether he had 1 wife or 2 wives. And so there's a dispute as to who gets the 50%, but the other 50% got split between their respective children. And in very rough terms, 1.9 billion was the value of YC's estate when he died, and 3 billion was roughly, I'm not giving the precise figures, was the value of YT's estate. So you can see these were, on any view, incredibly wealthy people. But the point was that by 2005, and this is what the evidence is, all of this may need to be tested at a trial, there had been a change of circumstances in that by then the children, when I say they were going to inherit, what they were going to inherit were shares in FPG. Their wealth essentially consisted of share, and FPG consists altogether, I think, of 9 public companies. There are 4 main public companies, which are referred to as the 4 treasures or something like that. But now what then happened was that, what are the facts? The trustees took into account in September 2005 the fact that the children were going to inherit this vast amount of shares, so that there was no need to incentivize them through GRT. That was their view of it, and therefore they decided to add Grandview itself as a beneficiary. Now, so those are the facts against which the issues have to be determined. Now, my Lord, can I turn first to the questions of construction of the trust deed? And we have the trust deed at page 370, which it starts at 364. Clause 8 is at page 370. Now, we would respectfully suggest it's not entirely clear on the appellant's case whether they are saying, as a matter of construction, you cannot add the GRT trustee. And Winston appears to say that by reference to 2 particular arguments. But what's not clear is whether it's being said, well, the so-called substratum argument or something along those lines is what prevents it. But let's leave that on one side and look at Clause 8 itself. Now, Clause 8.1.1 starts by saying any person or class or description of persons shall be included as a beneficiary for the purposes of this declaration. And it's the trustees may declare that any class, any person or class or description of persons. So, now, any is plainly unqualified. Now, it's also important that the power of addition and exclusion extends not only to any person, so you've heard submissions, oh, well, it's meant to cater for the widow of somebody or something along those lines. But you've also got to take account of the words class or description of persons. Now, then you have to go, when you see that, to the definition of person, which is defined at page 366 in a very extensive way, because it extends to any individual, company, partnership, an unincorporated association, any person acting in a fiduciary capacity. Now, one has to then go to the discretionary beneficiaries, or the beneficiaries as defined, which are then, as your lordships know, set out, and ladyship know, set out at page 376. Now, at attached to the date of the trust deed, the beneficiaries are subject to the exercise of the powers conferred by the trustees by Clause 8, the following persons, the children and remoter issue, and so on. Now, the power of addition obviously isn't intended to relate to the children and remoter issue because they're already covered. So you don't need to add them. Now, Clause 15 at page 372 says that every discretion or power hereby confirmed is absolute. Now, my Sir David Richards asked what's the authority dealing with these sort of clauses. There is a decision of the House of Lords in a case called Gisborne, which is in 1877, 2 Appeal Cases 300, where it was explained at page 305 by Lord Cairns that the effect of using these words is to give the trustees a very wide discretion with which the court will be slow to interfere. Now,
since you've given us that reference, does that mean it's not in our bundle?
It's not in your bundle.
Can I ask for it again, then?
Of course. That we can supply that to you.
Well, no, just give it now. Because
oh, sorry, you want the reference. It's 1877, 2 Appeal Cases, page 300.
Thank you.
Now, to be clear, we are not suggesting that, or Winston and Tony say, that this language does not disapply the proper purpose rule. Now, we agree with that. It's right so far as it goes, but it misses the point. At the first stage of the analysis, what is the scope of Clause 8 as a matter of construction? The existence of Clause 15 giving and confirming this very wide discretion as a matter for the trustee suggests that Clause 8 was not intended to be subject to some implied limitation. Now, where on the arguments have we been told there is a limitation? Now, the first point that is made by Winston is that he contends that Clause 8 did not permit a trustee of another trust to be added as a beneficiary of the GRT. He says that you cannot add a trustee of another trust. Instead, you have to add the beneficiaries of the other trust as beneficiaries of GRT. And that, he says, at paragraph 76 of his case. Now, the first thing we say is that this is entirely inconsistent with the language of clauses 1.1, 1.6, and 8. And the definition which you've seen of beneficiary, which takes you to Schedule 2, which takes you to Clause 8. And the question of construction, I would suggest, is a fairly straightforward one. When you read Clause 8, what is meant by person or class or description of persons? And that takes you to the definition clause, and particularly to 1.6. Now, so what is the answer to that? Winston says, well, 1.6 is subject to the overriding point that in the introductory part of 1, whenever the context permits. So his case is, well, the context of Clause 8 does not permit you to read person as including those persons in 1.6. Now, one might think, if they've gone to the trouble of defining person in this way, that would be some strong indication that it was intended to apply in Clause 8. Now, in fact, person would, we suggest, in any event, have included a person acting in a fiduciary capacity, even if 1.6 was not there. That's what we suggest you can derive from the authorities. And so that what 1.6 is doing is avoiding any argument about it by saying that person includes a person acting in a fiduciary capacity. But
I mean, words like that are normally included because there has been some general debate or maybe court decision that suggests that someone acting in a fiduciary capacity wouldn't be a person within this type of document. I just wonder whether there is some origin in the case law for this word.
The case law goes the other way.
I see.
So the two cases that we've referred to, there's a case called Harvey and a case called Triffitt. Harvey is at 4918 in the bundle, and Triffitt is at 5102 in the bundle. And essentially what those cases show is that a power exercisable in favour of persons may normally be exercised to benefit a person either personally or as an instrument of a purpose, regardless of whether the power is general, special or intermediate. But for our purposes, we say that is the position, as it were, as a matter of general law. But for our purposes, we have a situation where the parties have specifically chosen to use this expanded definition and to include any person acting in a fiduciary capacity. And of course, your lordship and ladyship will have noticed that the effect of... Sorry, my contact lens has been displaced. Sorry. I'll try and carry on. I can only see through one eye, so if I'm squinting, you'll excuse me. The effect of what is being submitted is to deprive those words, any person acting in a fiduciary capacity, of any meaning and effect. In effect, that you actually cross them out is really what their case would amount to. Now, so we say the first thing is the definition, that there's nothing in the context of Clause 8 to suggest that Clause 1.6 doesn't apply in full. So what is it Winston then says? How does he get to exclude persons acting in a fiduciary capacity? And his argument is this. He says, well, it's only the purpose of adding a beneficiary is to enable benefit to be conferred on that person. And so what, as we understand it, Winston means is that personal benefit. And so there's no point adding a beneficiary unless you're going to give personal benefit. And so, of course, the argument is just circular as put at 76.4. But what we've heard is arguments then by reference to clauses 3 and 4 of the trust deed, which are intended to suggest that you can't, if you have added somebody, you wouldn't be able to either make an appointment under clause 3. If you've added a trust, you couldn't make an appointment under clause 3 or a distribution under clause 4. Now, neither argument is right. Clause 3 allows, that's on page 367, the power of appointment, that allows the trustees to hold the trust fund upon such trusts in favour of or for the benefit of all or any one or more exclusively of the other or others of the beneficiaries. So if you have added the trustee of a trust as a beneficiary, then you're entitled to then hold some or all of the assets upon trust in favour of or for the benefit of, but let's focus on the words in favour of, such beneficiary. So there's absolutely nothing in clause 3 which
but
would...
the beneficiary there would be the trustee,
yes,
rather than the beneficiary of the
precisely.
Trustee.
It's the beneficiary is then the person acting in a fiduciary capacity. Yeah. So, for instance, if you appointed the trustee, a charity, or the trustee of a charity, it's the trustee who, on whose in whose favour you are then holding the trust funds. Not his, it's in he, and he is a beneficiary in his capacity as a fiduciary.
I mean, Mr. Talbot Rice's submission, I think, was focusing perhaps more on the word benefit,
Yes.
which is the word used in clause 4.
Yeah.
You're not benefiting the trustee, you're benefiting the beneficiaries or objects of the trust.
Yeah, I'm coming to clause 4,
Yes.
but you've got to start by first understanding, well, if you've added as a beneficiary a trustee of a trust, can you then appoint to a trust to hold in favour of that trustee? Answer, there's absolutely nothing to say you can't. Equally, now, clause 4, it's actually a slightly odd argument, the clause 4 argument, because it hasn't been suggested, even if grand view was added properly as a beneficiary, you couldn't make a distribution to them under clause 4 as a beneficiary.
I thought the argument was you couldn't add them as a beneficiary under clause 8 because they weren't a person.
Yes, what I'm saying is
you'd never, if they were right on that, you'd never get to this point. Obviously, if they're wrong on that, then
they don't run a subsidiary argument to say, well, even if you could add them as a beneficiary, you couldn't exercise, you were wrong to exercise your power under clause 4.
Well, that's because of the meaning you must therefore give to the word benefit under clause 4.
Well, it's not actually simply the word benefit, it's the word to in.
I see.
Now, what?
Apply the whole of the part of England to or, or for, yes.
Yes, and the submission that was made to you is that the word to adds nothing, it's effectively redundant, and that to or for maintenance, advancement, education, or other benefit of must mean any advancement, any distribution has to be for the benefit, personal benefit. And now, we would suggest that that is wrong. You were taken to, I think you referred to, but not taken to, a case called X against A, which is at 5806 and paragraph 45 at 5818. Now, the simple answer to that is, firstly, what you're concerned with is a question of construction of this trust deed. Now, secondly, in that case, X and A, there was a concession that at paragraph 32 that the charity to which a payment was to be made, the issue in that case was it wasn't a case about adding a trustee as a beneficiary. The issue was whether you could make a payment to or for the benefit of an individual by paying the charity. And that's what that case was actually about. So the actual facts of the case are nothing to do with what we're talking about. But the simple point we would make is this. If a trust deed does permit a person acting in a fiduciary capacity to be added as a beneficiary, it would be very odd indeed for the draftsman then to have said that the dispositive powers can't be exercised in favour of such person. So we say Clause 8 on its face doesn't have this limitation that you can't add.
I thought they were then saying it's because you can't make a disposition to them under Clause 4 that you have to read Clause 8 as being a context which requires a more limited definition.
But the argument is circular. I mean, it's...
Well, but what they're doing is construing Clause 8 by looking at how it fits in with the other clauses of the trust deed.
I understand that, but we say Clause 8 is a general and wide power. The reason person is defined in the way it is, we would say is particularly apposite for Clause 8, that there is nothing in Clause 4 to support the argument that a payment to isn't sufficient to deal with the payment to a trustee. And the point I would also make to your ladyship is this, that one can envisage, leave aside the facts of this case, one can envisage circumstances in which you wish to add as a beneficiary a trustee of a trust. There may be all sorts of tax reasons why that is advantageous. And what the case that's being made against us is, no, that's completely impossible to add any sort of trustee, including, say, a trustee for various of the children. In our submission, that would be a surprising conclusion.
Well, that's why they rely on Clause 9, then, to say that that's how you're supposed to...
I understand that. I'm trying to take the arguments in turn. I'm dealing with a different argument at the moment. Now,
as I understand it, Mr. Howard, you say, really, well, whatever the words for the benefit of may mean, and that might be a matter of some debate, you say, well, Clause 3 referring to trusts in favour of a beneficiary and making or applying capital or income to a beneficiary in Clause 4. I mean, that really, you say, that's the end of the debate.
I do.
Yes.
So I say on that point. Now, I then turn to the second point, which is by reference to Clause 9. And this point is actually a complete red herring, and let me explain why. We'll come on in due course to the debate about and who's right and who's wrong about what Clause 9 means. But let's just put it in context. Clause 9 is concerned with a transfer by the GRT trustee to a trustee of another trust in certain circumstances. Now, Winston's argument, the first step, is that such transfers must comply with a stricter remoteness of vesting rule than the rule that would otherwise apply, because he says the wait-and-see regime is disapplied. That's what he describes as the safeguard in Clause 9. He then says, and that's the second step of his argument, that if you could add a trustee as a beneficiary under Clause 8 and make a distribution under Clause 4, with the result that Clause 9 doesn't apply, then this safeguard, he says, would be circumvented. And so to prevent the circumvention, he says, you should hold that trustees are excluded from Clause 8 altogether. So it's impossible to make a trustee, add a trustee and make a distribution to the trustee without complying with the stricter remoteness of vesting rule. Now, the difficulty is that the argument is logically flawed and does not arise whatever construction you adopt of Clause 9. Why is that? There are two possible constructions of Clause 9. The first is that it does not apply to all transfers to trustees, but only to certain types of transfers to trustees. Now, that's the construction I will be inviting you to adopt when I address the issue in more detail. But if that construction is correct, there is by definition no circumvention occurring of Clause 9, because Clause 9, a fortiori, only applies on this basis to some transfers to trustees. In other words, if our construction is right, Clause 9 was never meant to apply to a transfer made under some other provision and is not circumvented, simply that isn't a transfer of the type that is caught. Now, if, on the other hand, we are wrong, and Winston is right, that Clause 9 applies to all trust-to-trust transfers, then no question of circumvention arises, because on that hypothesis there's nothing to circumvent. This Clause 9 safeguard simply, as he submits, applies. So there's no reason you can't add as a beneficiary a trustee. It's simply that the distribution to the trustee will be subject to a more onerous remoteness of vesting rule. That's all. So his case is any transfer to any trustee is subject to this more onerous remoteness of vesting rule. Now, we say that's wrong as a matter of construction of Clause 9, but even if...
you would say that even if the transfer purported to be made under Clause 4, it would still be subject to the proviso.
That's his argument. That's what he says the effect of Clause 9 is.
Yes.
So if that's right, then adding a trustee as a beneficiary doesn't circumvent that. He just says, well, Clause 9 applies. If Clause 9 is meant to apply to something different, then there's no circumvention. It's simply because it doesn't apply to a particular type of transfer. That's why I say it's logically...
Under his interpretation, you say Clause 9 applies and isn't circumvented. But what would be the effect of the application of Clause 9?
Well, the case that's made, my Lord, is that Clause 9 disapplies the wait-and-see rule. That's the argument in relation to a transfer to a trust.
Indeed.
Now, when we get to that argument, we say even if Clause 9 applies, there is no problem with remoteness of vesting in this case. That's a different stage of the argument.
Yes, now, just so that I'm following this, I think on, well, certainly the second of the ways you put it, I mean, Clause 9, I think, doesn't look like an independent power itself. It says any power hereby or by law conferred. The hereby is in the deed. Yeah,
exactly. No, it's not it's perfectly clear that Clause 9 is...
qualifying how other powers...
Yes, exactly.
Exercise.
Exactly. And the question is, though, is it... I mean, I don't want to get drawn into because I'm taking myself... this is part 2 of the case.
Yes.
The question is, in very simple terms, does it apply only to a transfer to a trust where others who are not beneficiaries of this trust are beneficiaries? In other words, we say it's actually quite a simple power. What it was intended to do is you could make a distribution which you say is for, say, the benefit of Winston by paying to Winston's trust, of which Winston and his wife, or Winston and his friend, are beneficiaries. So notwithstanding that potentially a non-beneficiary of this trust gets a benefit. That's what Clause 9 was about. But can I come back to that? Because that's...
But your second point is simply that is a point that you'll come back to. There is no circumvention, but on the facts of this case, there isn't a remoteness of vesting problem. That's essentially the point.
Well, that's a separate point, my Lord. The point on sorry, if I can take you back. The issue we're debating at this stage is there anything in Clause 9 which should lead you to a construction of Clause 8? In other words, in Clause 8, to lead to the conclusion that where it says person, it doesn't include someone acting in a fiduciary capacity. Yes. The argument that's made to you is you should exclude person acting in a fiduciary capacity from Clause 8, because that would allow circumvention of Clause 9. The answer to that is it doesn't allow circumvention of Clause 9. If, as Winston says, Clause 9 applies to all transfers to a trust, then it applies. There's no circumvention. Equally, if I'm right, Clause 9 is dealing with this rather limited category, or different category. It's not a circumvention, it's just Clause 9 is there for a different purpose. So, my Lord, we say that neither of those arguments relied on by Winston are correct. Now, we then have to consider the question of an implied term, and it's not entirely clear how seriously any implied term is sought to be put forward. It's not in fact clear any longer what the implied term is. Is it an implied term that no purpose trust can be added? That's what's in the written case. You can't add a purpose trust as a beneficiary. Or is it an implied term that you can't change the so-called substratum? We seem to have had different formulations. Now, whichever it is, we suggest that one does need to apply the ordinary law about implication of terms, And as the Court of Appeal pointed out at paragraph 184, which is at page 220, Clause 8 is perfectly workable as it is. There's no limitation that is so obvious as to go without saying. And what's more, its scope would be unclear, and we suggest that analysis is right. Now, insofar as it sought to be said, well, there's an implied term preventing the use of Clause 8 to alter the substratum of the trust. Now, and the substratum is said to be represented by interests of the Wang family. I mean, the difficulty with that is he's relying on an alleged rule that you can't alter the substratum. But once one realizes it's all just a question of construction, if as a matter of construction you cannot get the limitations that Winston wants, we suggest there's no basis for an implication.
Well, can it be, because the addition, the simple addition of another person, such as the WFT Trust or whatever, that of itself doesn't affect the substratum at all, in the sense of that no money is necessarily then given to that person. What is said to have destroyed the substratum here is the combination of the addition of the WFT and then the removal of the other beneficiaries and then the appointment of all the money to them. So I'm not sure that the implied term has to be that it destroys the substratum of itself. The implied term, I would have thought, is you can't add someone who is not at all in the group of the family, Wang family, sort of iustem generis with the people who are in Schedule 2. They've got to be of a similar kind, not somebody who's completely different.
Well, can I, because I think there are a couple of different points you've just made. First is that if there's a power of addition, I mean, if you can add a person, you then have undoubtedly, you can distribute the trust fund to any one of the beneficiaries. So once you've added somebody, if you can add them, there can't be any impediment. I mean, other than under the adequate deliberation rule, but as a matter of scope of a power, once they're added, I don't understand it to be suggested you can't distribute to that person. So taking your ladyship's point, oh, well, once they added them and then they removed everybody else and distributed, the removal actually is completely, it didn't make any difference. And the distribution is something you're always entitled to distribute to any particular beneficiary. So the case entirely turns on whether you can add.
Yes.
Now, then your second point is really the issue in the case, but as to how far does the power of addition go? Is it limited? Now, your ladyship put it as well, it must be eustem generis. Now, in our submission, that would be odd, where you have a clause which on its face says you can add any person. Any is rather inconsistent with saying, well, anyone who is of the same class. But the difficulty is, if you say it's anybody of the same class, because that's what eustem generis would mean, well, the class is children and issue, and they're already in. So it's not, in fact, even on your formulation, eustem generis. And that's the difficulty with the other side's case, is actually defining who it is that you're entitled to add on this basis. I'll come to the other argument which is raised. When you exercise these powers, you've got to be doing it for the benefit of the existing class. That's a different point as to the restriction. But if we're just looking at this as a matter of or implication of terms, in our submission, applying the normal tests, there is no restriction. Now, if I can just quickly deal with this point about, well, you should have an implied term that you can't add the trustee of a purpose trust. Now, the premise of the argument is that you can't add a bare purpose under Clause 8, because 1.6 only mentions persons and not purposes. So it said you can't circumvent that by adding the trustee of a purpose trust as a beneficiary. Now, the first point is the premise is wrong, because persons would, as a matter of general law, include persons as instruments to effect some purpose, and I refer you to Triffitt and Harvey. But in any event, the definition of person here includes someone acting in a fiduciary capacity. There is no restriction on the nature of the fiduciary capacity, and no reason for any restriction to be implied. And for instance, take the classic purpose trust, which is a charity. There's nothing here to say you can't add a trustee of a charity. Now, a point was made by reference to recital A of the trustee, that this is a private express trust. As the Court of Appeal pointed out, so is the Wang Family Trust. That's at page 227, paragraph 202. And we would suggest that the implied term that you can't add the trustee of a purpose trust would produce irrational results. It means that you can introduce a trustee of a private trust, but not the trustee of a purpose trust. So you can't add a trustee of a charity, but you could add the trustee of a trust for a person who has no particular connection with anything. Now, we suggest there's no reason why that could have been thought of. Now, can I turn to the proper purpose rule? Now, there are two introductory points that we would make about this, the nature of the rule and the approach to be adopted in applying it. First, the application of the rule depends upon identifying some purpose or purposes for which the power in question was conferred. And those purposes are the purposes which the donor who created the power. Now, we don't need to go to it now, we'll go to it later, but that's precisely what Mr. Justice Hoffman said in Re Beattie at 2368. Now, there is a potential question whether one is concerned with subjective purposes for which the donor created it, or whether it's objective purposes. Now, that doesn't arise in this case, because we say the answer is the same on either basis. We say the purpose of Clause 8 was to give the trustees maximum flexibility to respond to changing circumstances. One of the purposes of the GRT as a whole was to incentivize the family to promote the success of FPG and the vision of the founders. But that was all, both subjectively and objectively, a purpose of the GRT.
Well, where is it objectively? Where is there evidence to suggest that there's anything in this trust to do with benefiting humankind?
Well,
or incentivizing them to do anything in the company?
No, when one's construing the trust and taking account of the purpose of the trust, one is entitled, I mean, this is what Lord Sumption said in Eclairs, but this is absolutely the basic approach one takes to construction. One is entitled to look at the factual matrix. And part of the factual matrix is what the Court of Appeal have set out, which is the genesis of the trust and what, from the memoranda that were being exchanged prior to this, what was intended to be achieved. I took your ladyship to the Court of Appeal's judgment earlier today.
That, I mean, that is evidence of subjective motive.
Well, the thing is, when you're talking about a trust deed. I mean, and one talks about, let's take letter of wishes. That's why one can have a debate about what do you mean by subjective and objective. We all know when you're talking about a contract, because there are two parties to it, the objective construction is material that is capable of being known by both. Where you're dealing, and you're interested in, because you don't want to impose the subjective views of one party on the other. Where you're dealing with a trust, and for instance, letters of wishes, in one sense, that is entirely subjective. It's not part of the trust deed, or take what Mr. Justice Hoffman talked about, oral understandings. But so now it is objective in this sense that you look at the contemporaneous material and you work out objectively what does it mean. In other words, you can't have a set law come along and say, well, this is what I personally intended. I never communicated it, but this is what I intended. But you can look at what he was part of the background. So in other words, here, the communications about setting up the trust between Susan Wang and YC and YT, and there's a memoranda which you'll have seen referred to in the Court of Appeal, all of that is admissible as part of the background. In other words, you don't just look at the trust deed and the four corners of the document. It's admissible to look at that context.
I mean, I'd have thought that it has to be objective in the sense that it's creating rights and in particular obligations for trustees. So
I'm sorry, I didn't catch you.
A trust instrument is creating rights for beneficiaries, but in particular obligations for the trustees. So I would have thought that the trustees need to have a fair opportunity of knowing what their obligations are, which drives one to an objective conclusion, but it's objective as to the settlor's intention in setting things up. So it's not quite the same as objectivity in contract, because as you say, you've basically got a balance between potentially competing interests, and here it's just the bounty of the settlor, but it still has to be objective at some level.
Exactly.
In working out what that is.
That's exactly my submission. That's why the terminology can be dangerous in this area, but it's an objective test. You can't have things that are not communicated to the settlor, but the things that are part of the background which is being communicated by the settlor to the trustee, that is all part of what you can take into account in deciding what the purpose of this was.
But is it the purpose of this trust, or is it the purpose of the overall set of transactions that they did at that time, including setting up the WFT with much more money than was settled here?
The purpose of this trust was to incentivize the children in relation to what...
But how is that done under this trust?
How was it, sorry, I didn't catch what you said.
How is, in what context how does that incentivization work? Are you saying that the settlor would say to the trustees, oh, he's a real slacker, so I'm not going to give him any money? So what is it then?
It wasn't the settlor saying X is doing a good job. Just so the background was this: when they started to set up the trusts, the founders wrote a lengthy series of documents. It started with one document. At that stage, what was anticipated was that 17 children would in fact be directors of the trust company. And so then, they would get remuneration of some form which would incentivize them. It was then decided, as things evolved, that they weren't going to put all 17 children in at the initial stage. They were only going to put in 4 children as directors, and that's what happened. 2 from YC's family, 2 from YT's family. They set up the GRT, which was to be used. The purpose of it was to be there to incentivize the children, so that once you got to a stage that you did make them all directors, they all would be incentivized in that their interests in GRT, including their spares that they would get a payout, was aligned with FPG. So if FPG prospered, then this trust would also prosper because it had shares in FPG. And that's how the alignment of interests was taking place. But it never got to a stage where, I mean, GRT never actually made any distributions to any children because the children who were directors, they were never paid anything for their time and trouble, and the others weren't added at that stage as directors. But, I mean, those... I'm sorry, yes, my lord.
But I mean, anyone who gives a large block of shares in a company to trustees for beneficiaries or to people, I mean, necessarily those beneficiaries' interests lie in the continued growth and perpetuation of the success of the companies. I mean, it's not really a separate point at all, is it? I mean, you know, if you receive a large block of shares in a company, clearly your interest is in the success of the company.
But you're not receiving them personally. They're going into a trust of which you have a spares that you will get a distribution. So you have a hope that you will. Yeah. So it's more indirect.
But I mean, I find it just as, I mean, I see that the underlying idea of incentivizing the descendants and so on is a good reason for the trustees to retain the shares. I mean, obviously they actually could dispose of them shortly after the establishment of the trust, but it seems so intangible, really. It just seems to be necessarily part of having an interest in a business that you want the business to flourish.
No, but in fact, your lordship has really answered the point.
Right.
Because this is an incentivization, it meant to incentivize the children.
But to incentivize them to do what?
Well, but they are in due course to be directors and to act in FPG's interests. That's that's part of what's anticipated.
What were they to be directors of?
They were to be directors of the trust company, which then has enormous shareholdings in FPG.
Wang Family Trust?
Yes.
But they weren't, were they?
No, they weren't at the outset, but that's what was anticipated was going to happen. That was, so, my lord, the first
recipe for disaster, to have 17 members of the family sitting
that's, of course, your lordship may be right, and that's why it didn't, in the event, happen. That's, again, a complaint that's made in other aspects of the litigation. But the purpose of setting up the trust was to provide this means of incentivizing them. And I mean, taking your lordship's point, for instance, would the trustees have simply sold off? I mean, could they have said, well, let's sell off FPG shares and invest in BP because you get a better return on BP than FPG? Well, that would have been undermining what the purpose was, which was to align the children's interests with FPG. But it's also on the basis that they are going to perform this active role as, in due course, on the board of the trustees.
Okay, but what about the remoter issue?
I'm sorry, when you said...
Well, the remoter issue,
no,
I mean...
The plan is that the founders' vision was that FPG would go on and on and on.
Yes.
And what they wanted, you may say, well, the way of the world, that's not how it all works. They wanted their children and their grandchildren and their great-grandchildren all to be involved. So
in some other capacity?
In a capacity.
Other than as beneficiaries of the trust, I mean. Yes,
absolutely. Not simply, that's the whole point. It's not just that we're setting this up to give them bounty. That's exactly what it wasn't.
Yes, right.
Now, Tony draws a distinction between what he calls the fundamental purpose, which he says is the overall purpose of a trust, and the power-specific purpose, which he says is the purpose which is specific to a particular power. Now, in our submission, that's not a helpful analysis, because the real question is that which Mr. Justice Hoffman identified in re Beattie. What is the settlor's purpose for which the power in question was created? Now, of course, you look at all the admissible factual matrix, including the overall purpose of the trust, but the object of the exercise is to ascertain what was the purpose of the power. Now, I see the time. I'm about to move on.
Are you going to take us after the short adjournment to in re Beattie, or just giving a reference to it?
I'm going to come back to it.
We're going to come back to it. Well, that's a suitable point at which to adjourn then. Thank you very much.